My guest, Omorui Uyilo Edogewere, is a leading startup attorney and notary public. He has extensive experience in startups, technology, and innovation law with expertise in artificial intelligence and corporate commercial legal practice. Uyilo holds graduate and postgraduate degrees from the University of Lagos. He also holds a leadership certification from the Harvard Kennedy School of Government, a certification in artificial intelligence and law from Politecnico Milano, a certificate in principled and persuasive negotiation from the Yale School of Management, and a double specialization in legal entrepreneurship from the University of Maryland, USA, amongst others. I began the interview with his views on how technology and innovation has reshaped the landscape of privacy and data protection in the country in recent years.
I like to say that, and I say this often, that data is the new oil. And what that means is that advancement, economic growth, and development will all be centered around data. Technology and innovation are the key tools that will mine that data. And that's why I say startups are the miners of this new oil, this data, right? And startups thrive in the era of technology and innovation. The dynamics have changed from the data as we used to know it, right? Where people write down in paper and all that, to digitization. Today, with the advent of artificial intelligence, technology, the Internet of Things, you find data being mined without you even knowing it, right? Your mobile devices are collecting data. Even new age cars are getting data. Has reshaped how data is collected, right? You find that even in today's age, you think of a thing and the next thing you see carousels on your phone and they keep popping up, and in our own parlance, they are now which, right? Waiting with this, but that's the new reality. So a lot has now changed and has come to stay. And I always say, look, technology is a moving train. You either get in or it crushes you. It doesn't even give you an option not to get in. So what that says to you and I is that we must now rethink how we do things. We must now rethink data as we know it. We must now rethink the concept of privacy, right? Privacy is a constitutionally enshrined right. So what that means is that if technological advancements and innovation is changing the way a lot of things are happening, right, we must begin to rethink how to ensure that these enshrined rights are protected. When you look at what we have today, right, in the era of data protection, you have the developed world started with the GDPR. Africa has caught on it. Nigeria has caught on it. We had the NDPR. So today we have the NDPA. It has transited to an act.
NDPA.
Yes, right. The Nigeria Data Protection Act. And the implication of that really is to begin to contextualize our privacy realities and move towards protecting data. So today you have calls for DPCOs, DPOs. You are now asking organizations to be ethical with the utilization of data. There are now calls for data minimization, which means only take the data that you require. So the era of filling a full spreadsheet is fast going, right? But beyond all the rules and all that, the principal thing is contextualizing technology to our own realities in this part of the world. We are Nigerians, we are Africans, right? We are trying to catch up with the first world. How are we going to be able to ensure that the technology that we are deploying is bespoke to our realities? How do we ensure that in our own little way, our data is not being mined in an unethical manner? Part of this is by having rules in place, but most importantly, by ensuring that the utilization of technology is done in a way that we understand, and that data subjects, you and I, and that we understand that in utilizing the technology, we could expose ourselves. So the era of going on apps today without reading the terms of use has
done.
passed.
Because it's always so lengthy.
Oh no!
And we just
So
click, I agree, and we move
yes.
on.
So, but what are you agreeing to?
Most people can't be bothered to read.
For instance, a particular app at a time had a clause that said that all those who utilize their platform give them the exclusive right to use the user's information, their photographs, and all that they have uploaded on the platform in perpetuity and for any use that the company deems fit.
And we all just agree and just move on without
Right. But today, beyond even the user, that's why regulation comes in. So regulations will say, look, your terms of use must be in tandem with established rules and regulations, right? You cannot just use data carelessly. Today, the law is very clear as to what you want to use. The minimal data is the new name of the game.
I'm just wondering what role, because I want to talk about the laws now. What role do regulatory bodies like the Nigerian Data Protection Company play in balancing the need for innovation with protection of individual privacy rights?
Luckily, we now have a Data Protection Act. Unfortunately, the act is a bit late to the party, but better late than never. But also, it does not clearly envisage the speed of technological advancement.
So it's still playing catch up in some areas.
It's still playing catch up in some areas, right? So that speed of technological advancement, but you see, I always believe start somewhere, right? So we have a Data Protection Act 1.0. Maybe as time goes on, we have a 2.0, we have a 3.0. We continue to improve, right? But we are yet to even have an artificial intelligence policy. You can't really have an artificial intelligence act because before it has gone through all the stages of enactment, the AI has moved, right? And that's the speed. But policy, right? But we should begin to have policies that contextualize our reality. So what you have today is that we continue to lean very heavily on Europe and the Americas, where they have established procedures and policies. But technology must be bespoke. Its application must factor in the contextual realities of those who use it, and regulators must understand this in picking regulation.
So what do we need to be doing if we want to make it bespoke?
So for instance, right, in deploying technology, locally, our regulators must understand the kind of advancements and how they relate to the users in this part of the world, right? So the way I will use a particular device will probably be different from the way people in the US or in the United Kingdom will use it, right? And we must now understand these realities and bring it home and tailor it to suit our own realities, tailor it to suit our context. We're Africans, right? And certain things, for instance, that technology looks at certain things as being odd. We, in this part of the world, understand it. It is how we relate. It is how we live. It is what we do. Now, you cannot now bring a regulation that applies, sanctions on such things or allows such things to come and bind us when our realities are different, right? So contextualization is very important, if there's a word like that. Contextualizing is very important. But even more important is for regulators to be on top of their game.
What about our laws? How can our laws, because I know you mentioned that we do have a law that's late to the party.
Yeah, so we have the Data Protection Act, right? But the Data Protection Act focuses primarily on personal data, right? Protecting data subjects and all that, right? Which is good, which is a good start. But the Act must now look at strongly on the data implications of artificial intelligence.
And so that means those that are making the laws to also need to keep in touch with realities.
Right? Yes. But even more importantly is the need for our regulators locally to understand that data protection is not just a private sector thing, but also a public sector responsibility. So I want to see NDPC, for instance, work closely with NIMC, work closely with these agencies, and ensure that even government complies with privacy rights of data subjects. Because what you have is that government is the largest collator of data.
True.
Who is now going to hold them responsible and ensure ethical use of data? Can you imagine the data that INEC has mined in the last general election? How is the NDPA ensuring that that data is utilized solely for what it has been collected for?
I mean, we even had the case of someone on social media who said that one of the government official, I think JAMB, was getting in touch with her underage daughter just because she had provided that information.
Exactly.
So that's the illegal use right there.
So that's a very dangerous thing, right? So there's so much attention. The camera is all on the private sector, right? It's on the individual. Yes, it should be. But the camera should just as much be on the regulators and agencies of government who are collating data and who we are obligated to give our data to. So if I walk into a private enterprise and I ask for something and they ask me for data I'm not comfortable with, I opt to walk out and refuse to give them that data. But if I need an NIN card and I walk in and they ask me for certain data, if I refuse to give them, that means I am refusing to get a legal requirement that I need. So I am obligated. I don't even have a choice. I am obligated to give them that data. Now, as much as I am obligated to release my data, are they as obligated as I am to ensure that my data is properly used and protected? Cross-border transfer of data. I know national security, for instance, is an exception to some of these rules. But how are we also ensuring that that is also not abused?
What role can lawyers play in ensuring that proper things are done?
So having conversations like this, right? And in fairness to the NDPC, they have improved in their engagements. They have continued to engage stakeholders. And I think that what is happening today with them is a lot of knowledge sharing, best practice globally, working closely with other sectors to know what is best practice and how they've done that. So yes, that is being done. But as lawyers, you see, the concept of data protection is also not something that has always been there. And so you oftentimes hear people say, oh, this is a data protection lawyer. And I laugh and I say, we should all be data protection lawyers.
But then you become
right?
an emerging field.
Yeah, so it really should be what we all should know about. Because even as lawyers, we also have the blame. And in the era of social media, for instance, you see a lot of people publicizing information, especially businesses, So there's a thin line between trying to prove a track record and releasing your client data.
I wanted to round up talking about the general public. I know you've touched a bit on it, but how can they better understand and assert their rights regarding their privacy and their protection of their data in this increasingly digitized world?
I think I'll paint it this way. Data is gold. So you must now realize that everybody who you give your data to, you give a chunk of yourself and you are giving gold to, and they can use it in any way. So what that means is that the era of just filling forms for the sake of it has passed. The era of giving information, we like to sign up to so many things. So you receive links and you are signing up to so many things. That era has passed, because as you put your data out, you break the walls of your privacy. If I have your email address, I can access your digital footprint. And so every platform that you have gone on to with that email address, if I can utilize technology to assess and see everywhere everything you have done. And so even for cybersecurity purposes, data minimization is very important.
Security, yes.
Data minimization is very important. You must now start looking at giving only what is necessary for the purpose for which it has been asked of you, right? Those errors of so many things. You know, you see a form for a simple sign up, and they're asking you literally for an arm and a leg. That error has passed. So knowledge is power, and understanding that the more data you give, the more you break the walls of your privacy. Then understanding technology. We must embrace technology. It's the new normal, right? And we must embrace technology intentionally, which means that before you sign up to an app, you must understand how that app will utilize your data.
You must read the terms and conditions.
You must understand if you have the right to withdraw your data at any time you choose to do that. You will be surprised that some platforms don't give you the right. And then this is an era of digitization. So there is a black market for data. You don't want to be found in that black market. You don't want your data to be in that mix, because people will buy it and utilize it as they wish. Don't you get surprised that you receive some emails of the blue and you ask yourself, when did I sign up for this? Right? How do I?
Your information is out there in the parallel.
Your information is out there because there are people who will now collate. And this is one of the things that the regulator must now begin to sanction. So if I tell you that as an organization I have 5 million emails in my mailing list, how did I get that information? Do I have 5 million consent forms to show that 5 million people have consented to my utilization of their data?